everybody. Thank you for signing up and attending today's webinar. My name is Tim Ellis. I'm a partner at Enyo Law, responsible for much of the firm's ESG-related workflow. Along with Grant Thornton, Brett Court Chambers, we're pleased to have everybody with us today to discuss ESG, the good, the bad, and the ugly. Before we start, some minor housekeeping points. As you can see from our slide, there we go. Your microphones as an attendee will be muted. However, any technical issues with hearing speakers on the webinar, please deselect and reselect the computer audio button, as you can see on the slide. For any further technical issues you may have during the session, please click on the questions drop box, detail your technical issue, and one of the team will be able to help you from behind the scenes. For any content-related questions you have for our panelists, please use the same question drop box. All questions will be collated and answered during the designated Q&A session. The session today will be roughly 15 minutes of content, leaving us with 10 minutes of Q&A. Send your Q&A throughout the webinar. However, we will answer all questions at the end. We will be sharing the recording. We will be recording the webinar, and we will be sharing it with everybody afterwards. So if you do have other colleagues who like to have attended today but couldn't make it, either because they're busy at work or they're outside enjoying the fantastic London sunshine, please do send them a link afterwards. Now, to get us going, ESG has been a buzzword on the lips of many lawyers and corporates recently. The reality, however, is that none of this is new. Environment, social, and governance regulations have existed in most legal systems in various forms for many years. What is new, and why this area has become such a focus over the past few years, has flowed from three interrelated issues. First, a call from consumers, investors, and regulators for transparency from corporations as to what they're doing in these areas. Second, a shift of focus onto who corporates are engaging with, whether directly or indirectly, and whether those entities are good corporate citizens, for want of a better word. And three, a developing long-arm jurisdiction that has allowed individuals said to be impacted by ESG matters to bring claims in claimant-friendly jurisdictions around the world, with the English courts being at the forefront of some of these cases. Enyo, Grant Thornton, and Brett Court each have significant experience in advising and helping their clients navigate these issues. And I'm pleased to introduce a strong panel to discuss the good, the bad, and the ugly of ESG over lunch today. First, we have Shelley Horn. Shelley's a partner at Grant Thornton and leads its economic consulting team. She's an economist by training and has over 20 years of experience providing regulatory and competition economic advice, including giving expert testimony. She advises clients and provides expertise in a range of industries, although she has a particular focus on regulated industries, including communications, digital and healthcare, and the life sciences. And in particular, her team focuses on advising corporates on quantifying the impact of ESG activities, both to the company and the wider economic and social impacts, and on ESG in the context of litigation. That's something that Shelley will be talking about today. Second, Anna Brownrigg. Anna's a colleague of mine and leads the ESG initiative at Enyo. She assists clients resolve commercial and regulatory disputes through litigation, arbitration, and mediation. She has particular expertise in ESG-related issues. Anna handles a wide range of ESG disputes, often with a cross-border dimension. Anna works with clients to help preempt, prepare for, and resolve ESG risks before they escalate. And in that regard, regularly assists clients by providing them with risk assessments to help future-proof their business with a strong ESG agenda. Third, we have Steve Holt. Steve's a partner and head of investigations in GT's Forensic Investigation Services practice. He has a particular focus on aiding companies facing urgent, complex, cross-border issues, including fraud, bribery, and corruption. He has extensive experience advising and investigating high-profile public interest matters, representing governments, public companies, and private individuals throughout Europe, Africa, Asia, and South America. Finally, we are very pleased to have Professor Robert McCorquodale of Brick Court Chambers joining us. Robert is a Professor of International Law and Human Rights at the University of Nottingham and a barrister and mediator at Brick Court Chambers. He specialises in issues concerning corporate accountability for human rights and environmental impacts, and has advised companies, government and civil societies on these issues, and has appeared before the UK Supreme Court and the International Court of Justice. We're especially lucky to have Robert here today, as he has very recently been appointed by the United Nations Human Rights Council as a member of the UN Working Group on Business and Human Rights, which is a group of 5 experts from around the world. So with that introduction, I will hand over to Shelley-Ann to start with the good, the bad and the ugly.
Thanks, Tim. Yeah, I think I get the sort of maybe slightly easier job today, talking about sort of some of the positive aspects that a company can hope to achieve from investing in ESG. And when I talk about investing in ESG, I don't mean sort of buying stocks and shares and sort of financial investments. What I mean is prioritizing resources within your company, and how you can achieve a sort of positive return from focusing those resources. And I guess one of the things that surprises me, I've been talking to sustainability directors, NEDs, CFOs, etc., across a range of companies, from sort of smaller companies to sort of some of our sort of FTSE 100. And I think what surprised me to date is that a lot of this is being driven by legislation, it's being driven by regulation, it's being driven around a sort of need to manage risk. And actually, if we were thinking about investing in a factory, a new supply chain, a new process, a new initiative, there would be a business case behind it. We would work out that return on investment. What would the revenues be? What would the cost be? And what would the profit be? And therefore, should we move ahead with this decision or not? And actually, in the context of ESG, a lot of what we're seeing is it's being done piecemeal. So should we invest in this initiative, that initiative? What are the regulators saying? How far should we be going? And what we've been encouraging companies to do, and we've been having discussions with them, is around how you can look at ESG as an activity, and how you can develop a business case, a business plan for investing in ESG. So for achieving that focus within your business. And we're seeing sustainability directors increasingly wanting to do this. So I think they are looking at an inside-out view. So we talk about ESG materiality, and that's the materiality, the objectives of an ESG strategy, and how they can make a material positive impact, delivering long-term economic value. And that can be inside out. So that's the impact of an organisation on society and planet. And that's typically where ESG sustainability directors are sort of focused on, but also outside in, so financial materiality. So how can that drive the long-term success and sort of profitability of an organisation? And sustainability directors are increasingly becoming aware of the sort of the inside out and the outside in view, and the need to achieve both, but are actually struggling at times to get this on their board agenda. So as I said, we've been working with these companies to really understand the ESG landscape. So to help them understand that ESG matters to a range of stakeholders. So it's not just its employees, but it's also lenders, it's also the board, a whole range of stakeholders, but that each of them will have different objectives, and they'll have a different reason for you to invest in ESG, and they'll have a different required return from it. And it's around understanding those returns, understanding the stakeholders, and those returns for meeting those stakeholder needs that we've been putting in place a framework to address. So if we move on to the next slide. There we are. So the economic value of ESG is ultimately determined by what's material to stakeholders. So ultimately there's a cost of investing in ESG, and there are various ESG activities that can be undertaken, but each one of those will come with a cost, and each one of those will come from a value. So the first point is to understand who your stakeholders are, what they expect from you. So what's the bare minimum you have to do? What are your competitors doing? What are the requirements? That's what you need to sort of do to stand still. And then there's what more can you do? And whether you will want to do more of that will depend on many things. And one of those will be the return on investment that you get. And increasingly, ESG is coming into all walks of business life. So if we think about lenders have their own net zero balance sheet targets that they need to meet. And recently GT ran a survey, and we found that over 80% of lenders now require companies to have an ESG plan in place. And those that have a good ESG plan, not saying they have to be meeting the targets at the moment, but those that have an ESG plan that has metrics in and they have a plan to get there will typically be offered a lower interest rate, a bit better lending terms. And that's really important at the moment. We're sort of heading slowly towards recession. Cash flows are really tight, there's pressure on margins, and actually if you can get that lower working capital, cost of working capital, that can only be a benefit. There's also studies out there, for example, one by Bank of America, that shows those ESG companies, so those companies that have an ESG plan in place, an ESG strategy, are less likely to go bankrupt in future periods. And there's always an argument as to causality there. Is it those that are sort of facing bankruptcy don't have time to focus on ESG, or is it actually the focus on ESG is sort of reducing the risk of bankruptcy? But there were case studies there that we see lenders taking account of. There's also shareholders and investors. Shareholders and investors care about the firm's reputation. They understand the brand impact that ESG can have, and we've seen a number of ESG claims recently coming to light, and actually there's been a big reputational damage, and as a result of that reputational damage, the share price has fallen. And in some of these cases, the share price has taken a long time to bounce back. So what we're finding slightly different to some other sort of shareholder claims, so some other sort of securities litigation type claims, is that actually the ESG impact can be longer, the brand impact can be longer than for some other types of claims. Employees also require focus. We're in a market for talent, there's a shortage of skills, and ESG, firm inclusion policies, can be a way to attract and retain talent. Obviously regulators, I know Anna will touch on later, but regulators are increasingly requiring a focus on ESG. As a customer, so depending on what market you're in, so depending on who your customers are, there might be an opportunity to charge a premium for ESG friendly goods and services. So if we think about Tony's chocolate, we all pay an extra £1 to feel happy. I'm sure they will give us many reasons why there is a higher price of producing that chocolate, but ultimately we all pay an extra £1 because we want to feel happy, we want to buy happy chocolate. And even when the chocolate turned out not to be so happy and there were issues in their supply chain, they owned that, and to date there hasn't been some litigation against them, and their sales have stood up relatively well. Similarly, in business-to-business interactions, businesses have their own ESG requirements. They have to report on the activities of their suppliers, and increasingly businesses are requiring their suppliers to be ESG compliant. So if you bid for government work, for example, you now have to demonstrate your sort of ESG credentials, and that's the same in many other sectors. So ultimately, if you want to do business, you might be able to charge a higher price depending on what customer group you're in. You might be able to use it as a way to differentiate your product, or it might just be a must-have if you want to continue as part of that supply chain. So what we do is, as we undertake these materiality assessments with firms, we're starting to map out these stakeholders. And to be fair, they're broadly similar for each corporate. We map them out and we try and understand what matters to the stakeholders. As if we can understand what matters to the stakeholders, then we can understand the value that the company will obtain by addressing their needs. And if we move on to the next slide. So there are many tools and techniques for estimating the return on investment from ESG. And I won't go through them all today, but to say, it's a fairly sort of standard business planning approach. So as you think about initiative, you try and work out, will my revenues increase? Will my costs change? So will my costs go up because I'm undertaking the initiative, but could they fall? So for example, because I'm getting a better lending rate, etc. And you can do this in the context of deciding whether to invest in an initiative. So you essentially work out what your counterfactual is, what will happen if you don't invest in ESG versus the value of uplift of investing in ESG. And there are a number of reasons to do this. One is that if you are a company and you're thinking about investing in new or undertaking new ESG activities, you want to know the return on investment. However, it also comes into play during transactions. So we've seen recently, for example, that Oatly milk has IPO'd at a premium or above what one might expect. And you look at sort of Alpro, you look at Oatly, you look at other types of milk, and you could argue that actually Oatly has fantastic branding, it has great packaging, and maybe that's why people are willing to pay more for it, and maybe that's why the share price is higher. Alternatively, it might be argued that there is actually an uplift, a premium for being good. So they had some very ESG friendly statements in their share prospectus, and maybe that contributed to the higher to the higher sort of IPO price, to the higher share price. And there are various tools and techniques that we can use to sort of estimate what that ESG uplift might be. Of course, the downside to that is if you say something in your annual report, so in your share price prospectus, and it turns out maybe not to be accurate, there is the potential for claims down the line against you. So it's very good to sort of estimate the value of being good in ESG world. And so there are many ways to estimate that. But also, if you're going to sort of start making those public statements, now, and we'll cover this later on, it's really important that they are correct, sort of backed up by fact. In terms of some other tools and techniques worth pointing out, there is customer demand at the moment for ESG friendly products, and that's retail consumers, it's business customers as well. And there are various tools and techniques you can use to estimate that. So, essentially that will allow you to work out what the optimal price point is. So if you undertake a set of ESG activities, you can market potentially yourself in a different way. You can maybe find yourself in a different market, and that might allow you to charge a premium on the products. And there are tools and techniques that allow for that. So I guess my message today would be there are some really great reasons to invest in ESG. And a lot of those are financially driven, and there can be a positive return on investment to ESG. And we see that from various products in the market. We see it in transactions as well, but it's really important to take an appropriate approach to measuring that. And it's really important to communicate that clearly and concisely. On that note, I'm going to pass over to Anna, who's going to talk about some of the risks associated with ESG.
Thanks, Shelley, and afternoon, everyone. So Shelley has spoken about the benefits of having an ESG strategy. And what I'm going to talk about is the risks that come with articulating that strategy, namely, and I think nothing I want to say should take away from the points that Shelley has made and the importance of businesses focusing on ESG. But it's important to consider when doing so how those risks arise and what can be done to mitigate them. And before I start speaking for this, I think a relevant question is, what's changed and why is this such a concern for businesses today? Companies, particularly public companies, are under increasing pressure to publish information about their ESG credentials. And Shelley has alluded to that in her talk. And I think the reason for that is the pressure is being generated by investors, with a growing number of investors only wanting to invest in companies with strong ESG credentials. And secondly, as I'll speak to, regulation around ESG and ESG disclosure resulted in three major developments. The first development being that we've seen a really sharp rise in voluntary commitments around climate change from corporates. And a good example of this is the race to net zero. So many people listening today will be familiar with net zero and what it means. The UK government has a net zero campaign and target which sets out how it plans to decarbonise all aspects of the UK economy by 2050. But it's not just governments that are setting net zero targets. We're also seeing corporates under pressure to make similar pledges and then to articulate to their stakeholders and to their shareholders how they plan to achieve them. And in addition to voluntary pledges around climate change, we're also seeing voluntary pledges around other aspects of ESG. So Shelley has mentioned Tony's chocolate. They operate under the slogan, let's make chocolate 100% slavery free. And we've also seen statements from Dyson in their modern slavery reporting, which claim to have zero tolerance to modern slavery. And just on the climate commitments, I think to give an indication of the sheer scale, in advance of COP26 in Glasgow, I think it was 2,200 companies made net zero commitments in the year preceding COP26. And now 60% of the UK's largest businesses have signed up to the UN's Race to Zero campaign. So there's a sharp rise there. And then finally, we're seeing a sharp increase in mandatory regimes where companies are required to make ESG disclosures. Two examples of recent changes there. In the US, you've got the SEC, the Securities Exchange Commission, which has now proposed that all filers, including private foreign filers, publish information about their emissions. And that's going to have a serious impact if that goes through. And secondly, in the UK, it's already mandated that a range of companies report on climate risk in accordance with the recommendations of the Task Force for Climate-Related Financial Disclosures. otherwise known as the TCFD. And to give you an indication of the scale of that mandate, in the financial year 6th of April 2022, 1,300 of the UK's largest institutions and companies are mandated to provide TCFD reporting. So it's already happening, that change in regulation is already upon us. And it's not just the financial institutions, but other institutions, as I'll talk to, making an increasing number of ESG disclosures, either because they want to, or because they're required to, or a mixture of both. And this brings with it risk, because companies expose themselves to enforcement, reputationally damaging litigation if their ESG disclosures are somehow incomplete, don't comply with the regulations, or are inaccurate or misleading. The risks, the first risk I think worth mentioning is the risk of regulatory action. So the expanding regulatory frameworks and really clear statements from regulatory authorities of a desire and strong desire to target and combat greenwashing and misleading ESG disclosures means we're likely to see a sharp rise in enforcement activity in this area. And we're already seeing this in the US. The US SEC has a ESG and climate task force, and that task force has already shown that it's willing to go after statements made in sustainability reports and product filings as a basis for enforcement actions for fraudulent mistakes. And to give you an example, in April of this year, the SEC started an action against Vale, a global mining company, alleging that it had misrepresented in its ESG disclosures. So it's already happening in the US, and I think we can expect to see similar action in the UK, although it's fair to say that we're slightly behind. So the FCA has said that it expects to set the highest standards for financial services institutions to avoid questionable green claims being made. And it said that enforcement could be brought if ESG disclosures were not made, or if they were somehow inaccurate, misleading, or constituted improper conduct. So it's really important to be aware of those risks. And those risks that I've mentioned already are in the financial services sector, but really we've got other regulatory authorities looking at these issues as well. So to give an example, in 2021, the Competition Markets Authority, the CMA, published a Green Claims Code. Under that Green Claims Code, one of the principles is that environmental claims must be clear, they must be accurate, they must not be misleading, and they must not hide or omit information. And where a business is found to infringe a consumer protection law, they can bring litigation proceedings on the basis of that Green Claims. So that's already starting. It's important to note that the CMA has already started looking into environmental claims made in the UK fashion sector. So watch this space to see what happens there. Now I've talked about regulatory risk, and I want to talk about litigation risk, because businesses that make false or inaccurate or misleading ESG claims, and I think it's important to start with financial firms, because there's been a lot of commentary and regulation around this. And for financial firms, I think the main point to be aware of is that they can expect to have the kind of more challenges and more scrutiny on the so-called ESG credentials of their so-called green investments. And particularly listed financial services firms need to really be alive to the risk of securities claims being brought under the statutory regime set out in Section 90 and Section 90A of the Financial Services and Markets Act, otherwise known as FSMA. And I think those claims can be based on misleading and inaccurate ESG. So what these securities claims can bring can be very damaging to a company. And so when you are marketing investments as green, companies need to be very careful. And in the UK, I think it's fair to say that these sorts of claims are still relatively uncommon. but we are expecting these claims to increase if, as anticipated, we have regulators that start to levy substantial fines against firms and businesses, and those fines or publicity around such cases leads to drops in the company's share price. And that's really what the FSMA claims are about. It's where investors are seeking compensation for what's known as a stock drop. So to give you an example, you can have a company that's caught making false greenwashing claims about only getting its energy from renewable sources. That might cause, or those claims might cause damage to a company's reputation and cause a fall in its share price, resulting in investors having potential FSMA claims. Now, before I move on to other types of litigation risks, I think it's important to note that for the Section 90 and the Section 90A FSMA claims, they are slightly different. So Section 90 enables investors who have acquired securities to bring claims where they've suffered losses resulting from false ESG statements in listing. Whereas Section 90A is slightly different in that it enables holders, buyers of securities to bring claims in relation to false ESG statements where those have come in other published information. So it's slightly broader, looking at annual accounts, for example, and reports. Outside of the kind of financial sector, or in the financial sector and in other sectors, we can expect to see a much wider range of claims. So we can expect to see claims under the Misrepresentation Act, in negligent misstatement, and also in the tort of deceit for fraudulent misrepresentation. Claims can be brought against both public and private companies. And I think in the coming years, we can expect to see a really large number of claims in these areas based on what companies say they're doing versus what they're actually doing. And I think it's also important to remember that I've talked a lot about kind of financial disclosures and climate disclosures, but these claims can be brought in relation to a really wide range of statements. And so companies shouldn't just be concentrating on those types of statements, but also, what are you saying in your sustainability report and other kind of ESG related documents, so your wide ESG disclosures. My takeaway from today really is that companies should manage and review their ESG disclosures on a really regular basis. And they need to do that to mitigate both the risk of regulatory action, but also the risk of costly and reputationally damaging litigation. So I think it's really important for companies to ask, if you are required to make an ESG disclosure, make sure it is complete, accurate, and not misleading. And where you're thinking of making a voluntary ESG disclosure or a voluntary ESG statement, it's really important to ask, can I stand behind that statement, that metric, that target? And do I have a document trail which shows, which will enable me to evidence that that is a legitimate target or statement? And finally, to keep it continually under review. So companies who have made ESG asking, have circumstances changed such that that ESG statement is no longer relevant and needs to be withdrawn. So that's my takeaway. And now I'm going to hand over to Steve, who's going to talk about what you do when things go wrong.
Thanks, Anna. Well, that I think very nicely brings us on to the ugly, I guess, or is it the bad? I'm not sure. I've been called both in recent times. I'm also mindful that I'm the accountant sandwiched between lawyers, an economist, and a barrister. So time is likely to be something of a premium. So I'll run through this part fairly quickly. To set the scene, I'm Steve Holt. I'm a partner at Thornton. I'm the head of our investigations practice, which essentially helps clients to navigate challenges by finding and using information that helps guide your strategic decision making, largely around risk and dispute issues. Now, in recent times, what this means has shifted a little from purely understanding the financial impact of disasters, such as the Buncefield oil explosion, or working with companies and navigating matters that bridge the political and business worlds, so things like Lava Jato in Brazil, to looking at crises through a much broader lens. And that, I think, speaks to our role investigating the supply chain allegations at Boohoo a couple of years ago, or some more recent work with the Church of England and helping it understand the extent to which its current financial position can be connected to its participation in the transatlantic slave trade. Both of those are in the public domain, by the way, and I reference them more to provide a little context to my next comments. I really dislike the term ESG for two main reasons. The first being that it's a pretty meaningless collection of words. It permits its own definition when considering its application to business. What's solid, what's pragmatic ESG policy to some is akin to setting up a brand new airport in your back garden to others. It's also a really transient assessment. What's good today isn't necessarily good tomorrow, and it's impacted immediately by broader issues. Just see how quickly proponents of various ESG issues changed their view overnight when the war in Ukraine started. The second reason is that it also indicates an order of preference. Now, recent studies by a well-regarded financial services consultancy, let me know if you want me to point you in the direction of that afterwards, found that sophisticated investors prioritize E to S and then S to G. But surely that doesn't mean that you can pay bribes to operate your business as long as you stop your team from traveling to pay those bribes. Many don't see or really understand that having a strong governance environment really helps to guide and normalize activity in your environmental and social spaces. What these studies also found around ESG is that people want evidence of action supporting an ESG statement made by a company, but they're not really that bothered about the quality of the evidence that's provided. And this is where the bad, again, or ugly, depending on your viewpoint, comes in. This lack of interest in the quality of evidence only holds until something goes wrong, or is perceived to go wrong, which is very important, at which point it becomes paramount and tricky questions start to appear from all corners of your stakeholder spectrum. The real challenge here is it doesn't matter if something actually has gone wrong or is going wrong. It's if there is that perception that something isn't quite right. And this could come from media allegations, it could be whistleblower reports, it could be poor financial results, it could even be misguided statements by executives. Then we immediately start to see a value decline for those who have made those strong ESG positioning statements that Anna was talking about. We see time and time again the reward that's there for those that don't sweep the issue under the carpet, but proactively engage with the problem. If you talk the talk, you have to walk the walk. And by doing so and demonstrating strong leadership, you protect and you enhance shareholder value. So what does walking the walk mean? Easy to say, hard to do. Typically, it involves adopting increased transparency, it involves assessing the situation and holding your hands up when you get something wrong. Everyone gets things wrong from time to time, but it's almost a truism in the corporate world that you can't get something wrong. To get to a decision point where you make any of those actions, however, you need to have the facts of the matter at your fingertips, and you probably need an objective viewpoint. And that's where an investigation comes in. And apologies for the bold sales pitch for how amazing investigations can be. When you need to understand a series of events, whether it's current or historical, and the impact of those events on your business, based on data that is either at your fingertips or you can discover through open source intelligence inquiries, from an objective perspective, bring in somebody to support and help guide you. And this could be from greenwashing allegations to misconduct, mismanagement, misreporting, supply chain problems, modern slavery allegations, and so on. There's so much value we see in there being this independent voice that helps guide how corporate navigates a problem. Practically as well, there are so few boards, executives, or senior managers who should be able to list dealing with these problems as their key day-to-day activity. If you're spending all of your time firefighting, there's something bigger at play in your business. Instead, you should be focusing on long-term shareholder value development. As Shellyan alluded to, the value in ESG is doing things over the long term. So in my brief remaining time, I'll highlight a couple of things to expect or be mindful of when you're conducting an ESG investigation. There isn't a tick box. There isn't you do this, then this, then this. Every situation is different. Every company is different. Every risk is different. So I'm afraid I can't just give you a performance, say, right, off you go. But there are three things that I think come through time and time again. The first, like in every situation, communication is key. It is likely you're going to have actively involved stakeholders who want to know what you're doing, what you're finding, and how you're going to respond. Some of those will be well-wishers, others will be seeking to detract from every step that you take, making sure that any communication, and you don't have to communicate, but is well guided, it's with stakeholders, it's properly managed, is vital to value preservation. The second, and this almost goes against my previous pitch for investigators, is that you need to set well-defined terms of reference that address the concern when you start something. The goal of an ESG investigation, inquiry, any investigation really, however you want to frame it, is not to dig and dig and dig until you find something bad or unpalatable that the company's ever done. Rather is that you're seeking to address a specific issue in a practical and pragmatic way. This doesn't mean that you sweep everything else under the carpet. By all means, you don't ignore all the red flags that might present themselves during the course of whatever work you've done. Keep in mind throughout the core purpose of what you're trying to do. And the last is, you'll find problems. Some of them will be within your control, some of them may not be. Any findings, any communication that suggests a completely clean bill of health is just not credible. Even the best run companies have flaws. They have areas they can improve in, they have things that they can fix, and the key is to acknowledge it at the outset. If you look at companies like Unilever, for example, they know they have modern slavery within their supply chain. They make public statements about it. Now, I'm not going to say that Unilever does this in the best way, but they grasp the issue and they deal with it. And what really matters is the extent to which you can substantiate key concerns and then demonstrate how a company is going to move forward with resolving the concerns. Nobody needs to sit in the past. Everyone wants to move forward. And those are my three top tips I suggest for conducting an ESG investigation. And with that, I'll now hand over to arguably the star of the show, Robert McCorquodale.
Thanks very much, Steve. I doubt very much if I'm the star in any way, though I suspect after your talk, I'm probably dealing with the ugly and probably even more the scary. Jessica, if you could move to my first slide, which is perhaps the most scariest. This sets out some of the breadth of regulation that are happening at the moment. Anna's mentioned a couple of them. And so this is already out there. It's not something new, but it's going to come and increasingly at a great rate. So there's a number of different forms of regulation which will happen in the ESG space, not always called ESG. And I'm going to tend to focus on the S part with some of the E part, but as Steve notes, there's a consequence to those in relation to governance. So as I look at my next slide, a core element of this is the idea of human rights due diligence. And human rights due diligence has a particular expectation and idea. The starting point is there should be a policy about what you are actually doing. And what that requires is an assessment. What are your actual human rights risks? And remarkably, that means looking at what the risks are on the ground, not just business risk. So there needs to be a proper assessment and not an assessment prejudging it. I worked, for example, with a telecommunications company, and they worked out what their particular risks were, but they completely neglected the fact that they were putting cables across land, which was often indigenous land, or communities were being moved because of it. So it's thinking about the broadest areas of risk in relation to your assessment. And then doing obviously your best to cease, prevent, or mitigate that. And sometimes that includes terminating a relationship with a supplier. And then tracking what's actually happened. What have you done? What have you gone forward in order to look again at your policies and processes? And finally, communication. That can be very hard, particularly for lawyers in companies, but it's crucial. And Steve talks about how Unilever has done this. Another example is Nestle. They actually have a report called Walking the Talk, in which they showed that there were some things that they didn't do very well, but they relied actually on that report as a reasonable defense in a claim against them. So there are definite benefits in doing this assessment and doing it well, not just as a kind of a casual look. And so as my next slide shows, I particularly wanted to indicate what human rights due diligence means, perhaps in contrast to the areas that you're most familiar with, which will probably be business due diligence. And so firstly, it talks about how a business enterprise, that's the terminology, could cause or contribute to human rights and environmental impacts. And that also includes how they can be linked through their business relationships, which could be their supplier, their subsidiary, or any other kind of business relationship. And the risks are about to the rights holder, as I said before, not just the risk to the business. So you start looking at what's my employees' risks, what are the risks to the community, what are perhaps the risks to consumers, what are our investors' risks, before then you consequent risk to the business. And one of these core elements is to talk with your stakeholders. Time and time again, I find companies suddenly get hit with a litigation issue and they're completely surprised by it. Why? Because they haven't consulted with the stakeholders. In fact, I often hold up my phone and say, this is a huge risk, because you don't need investigators, journalists investigating for years and years. You might just need a photo from one of the community showing that, for example, you have a child sewing shoes together and showing then evidence of child labour. So consult with the stakeholders. But of course, not everybody can do it as well. If you're a medium or small enterprise, you may not be able to do it quite to the same level that a major enterprise might do. However, you might be down the supply chain or up the value chain of the large company. So you may have expectations on you. And there are going to be certain areas, such as if you're in a conflict zone, such as the Democratic Republic of Congo, where your expectations are going to be higher for what you're doing. The other thing, contrast, say, to a merger or acquisition, it's an ongoing expectation, a regular human rights due diligence, and perhaps if you enter a new field or a new operation, you need to do it again. And as Steve says, it's not just a tick box. And therefore, these are the kind of things that need to be thought about. And it's already in place. And Jessica, if you could move to the next slide, please. I'm going to look at the most recent proposal from the European Commission called a Corporate Sustainability Due Diligence Directive. Now, this builds on existing legislation that's already in France, in Germany, and in Norway. And that covers a range of companies, as you can see there, a threshold of 150 million and of global turnover or 500 plus employees. But in certain areas of high risk, such as textiles, agriculture, and the extractive sector, that's much lower because the risks are higher. And what's interesting, it covers not just EU domiciled companies, but also those operating in the EU. So it is going to be relevant for UK companies, many of whom either get goods through the EU or trade within the EU. And it includes not only the actual operation, but the subsidiaries and along your business relationships. Doesn't particularly apply at the moment to small and medium-sized enterprises who are engaging with financial institutions, but that may change. And as I've already talked about, it's this due diligence idea, once again at the forefront of this, in relation to, in this instance, human rights as well as environmental impacts. And they also indicate that there's going to be a requirement for a climate change plan. Not yet due diligence, but it may, I'm certain it will come in. The other thing to flag and relevant for governance is it indicates that directors will have increased duties in this area, that they need to oversee it and show that they're overseeing, not just write a kind of a statement in a sustainability plan and not do much about it. And in doing that, they need to consider not just their shareholders, not just their investors, but all stakeholders. And then on the next slide, one sees that there are other consequences as well as reporting. There's civil liability for harms by the corporation and through their value chain, and includes harms outside the EU. So it's not just an EU-focused law. But what's interesting is there's no liability if a business seeks some kind of protection through, perhaps they've undertaken their human rights due diligence, and therefore, like Nestle, they're able to prove it as a defence, as well as, in the way that Anna talked about, increased powers to the regulatory bodies. So this is an indication of just part of this rapid movement on legislative developments. On the next slide, though, I'm going to just mention some of the cases. You'll be pleased to know I'm not going to go through them in detail. But these are the cases which have expanded and expanded responsibilities for corporations. The first one, which I declare an interest I was involved in, Vedanta Resources, was the first time any court across the world had made the decision that a parent company has a duty of care to the actions of their subsidiaries which affect victims. In this case, it was a copper mine in Zambia. And in that instance, the court was also shown evidence of what Vedanta had said in their sustainability report, very far from what they actually did. And a similar case against Shell, both in the UK and in the Netherlands, where they found Shell had breached their duty of care and needed to do a whole lot of things. And then taking it one step further, much more recently, the District Court of The Hague found that Shell, again, in this instance, had breached their duty in relation to climate change and to undertake to reduce by 45% their scopes of emission by 2030. That's a significant step in these developments. But it's not only in this area, it's also coming up in investment arbitration, a case of Abasa in Argentina in relation to use of water, where the companies, how they'd acted was relevant. In Nevson and Araya, a case where a company had been working with the Eritrean state organization. That wasn't good enough. They could still be held responsible. And also outside the direct litigation, but in the mediation area, there was a case brought against JCB for its goods, which it sold on, in this instance, to Israeli settlements. And the body held, you hadn't done enough, you hadn't done your due diligence. So it's not just in your supply chain, it's also when you're selling on. And a similar case, just to pick up something Anna mentioned, against ANZ, Australian New Zealand Bank in Australia, for their financial actions in relation to Cambodian sugar, once again held that they hadn't done their due diligence. And finally, as a warning, sorry, just to go back one step, please, Jessica. Finally, as a warning, there was a case brought against the executives, the CEO and the senior executives of Amisis and Nexa on the basis of crimes against humanity, because they'd worked with armed groups and hadn't taken consequences that there might be on human rights terms. Thank you. Now we just pop to the next slide. This next slide shows why on earth are businesses interested in this. With my professor hat on, I did a survey for the European Commission looking at what businesses want. We surveyed 631 companies, and the overwhelming majority wanted good regulation on this. In a way, as Shirley mentions, it's all over the place a little bit what's happening, and they want clarity. So surprisingly, businesses do want this. I've sat in committees where businesses have said, we need this in order to be able to show our suppliers what is required. So there's a quite groundswell of support for businesses. And finally, on my final slide, just to bring it all together, I focus mainly on the social and showing how human rights have real impacts and real requirement to look at them, and the need for consultation. But there's also environmental due diligence, also climate change, as I mentioned, and in fact, even the UK has passed Environmental Act just recently, which deals with deforestation. And obviously there are impacts on that. But what does that mean for governance? I don't think, I agree with Steve, it's not governance at the end, it's governance right the way through this. Not only directors' duties, which I mentioned, but also investors' expectations, as Shellyan was talking about, and the risks. There are risks clearly of litigation, which I've talked about, but all the other risks, which all four of us have talked about in terms of operational risks, financial risks, and even employee risks. How many employees want to work for companies which are constantly be found to be breaching these kind of areas? So what I hope to show here is that the law is working rapidly in this area, that it's not something just to be left behind, but to be ahead of the game. It's necessary right now to begin looking at these issues. Thank you very much, and now I hand you back to Tim.
Thank you very much, Robert. And thanks also to Shellyan, Anna, and Steve. I thought that was a very, very useful look at the issue across the different perspectives that I think gives you a real sense of the risks and also the opportunities that arise from this greater focus on ESG. And I think one thing that's clear from all of it is that whilst obviously there are opportunities, if as a corporate you are making promises or you are required to do things by way of legislation, if you do not do what you say you're going to do, then the risk of being pursued by the regulators, having your share price attacked by investors, or being the subject of very, very significant litigation is very high. I just wanted to move over to the Q&A section. I actually wanted to start with a question from Robert. Robert, you talked about I guess the breadth and the disparity of legislation on these types of issues all over the world. That's something that we've come across at Enyo in trying to advise clients who are multi-jurisdictional. They have offices all over Europe, all over the world. And what they want is exactly the point you said before. What they want to do is work out, well, how do we create something that works across all jurisdictions? And I can say to my people, and I can ensure that the governance processes are in place so that they can actually comply with it. Because it doesn't work if you've got a situation where employees working in multiple jurisdictions, there's a policy for one that's different to the policy for the other. It just can't work. Do you know whether there are any sort of steps or initiatives whereby there might be some more uniformity in legislation across any of the major jurisdictions going forward?
Thanks, Tim. It's a great question, and you're quite right. There is a sense to which companies would like this. I guess there's two developments. The European Union development is huge. Why? Because otherwise it's been very piecemeal across the EU, and I think that suddenly if you get all those member states operating on it, it'll begin to be a template for what happens elsewhere, including potentially the UK. I also think related to that is there is a development of a business and human rights treaty, which I've had some involvement, and I think that could once again set a framework. The difference often at the moment is between the global south and the global north. Most of these differences happen in the global south, but not only. Boohoo, as Steve talked about, was an example in the UK. And so I think that they are beginning to create these kind of templates. The same sense, there are some states which have laws which go completely against this. There are laws, I've worked with companies where in some states it says you cannot employ a senior woman as your CEO. You cannot employ someone of a different nationality as your CEO. How do you work around those is part of the skill of the advisor. So I think that, yeah, it's definitely developing in this way. I think we're still some distance to get there.
Yeah, and I think to pick up on your last point, there are some countries that it is impossible to work in whilst complying with these obligations, and that puts corporates who have operations in those companies in a very difficult position. They need to make a decision as to whether or not they're prepared to continue and take the risk, or whether or not they get rid of their investment and get out.
Yeah, I agree. Sometimes they can work around it. I work with a company which there was a nationality issue and they had non-discrimination policies. How do they do it? They actually set the real CEO in a different country, and there was somebody who was notionally the CEO in those. They got around it, but it's not very easy.
Just picking up on that same point, Anna, can you sort of talk us through what the practical things that can be done by corporates in order to protect against this type of risk? I think you're on mute, Anna.
You should be able to hear me now.
We can hear you now.
Yeah, great. I think the focus really needs to be on companies, like I said, reviewing and managing how is ESG performance being monitored. And if it's being monitored, is it being recorded and verified with a proper process? So I think that's the kind of first milestone to reach. And then I think companies need to then look at what are the statements that are going out. So, you know, checking where are you making ESG disclosures, where are you making regulatory announcements, and not only making sure are those compliant with the kind of different jurisdictions. So Tim, that goes to your point. It's not just going to be the jurisdiction where you're incorporated. It's also going to be the jurisdictions where you have bodies. It's going to be the jurisdictions where you have operations. So making sure that you're complying. And then on top of that, what companies need to do is they need to make sure that their internal processes, their internal policies and procedures and audits are making sure that they are compliant, but also looking forward. So what's the next thing that they need to be aware of? And I think the due diligence directive well for a business to be compliant today, that these regulations are coming thick and fast, and companies need to make sure the process is in place ahead of time, so that when it comes into effect, you know, that everyone's not scrambling around to make sure that they're doing the right thing. Finally, you know, taking advice, working with advisors, making sure you've got the right staff and expertise, know what you need to be doing, and to understand, you know, how to mitigate some of the risks that we've been talking about today.
Tim, can I just jump in on Anne's point about thinking ahead? So we did an event study looking at the reputational damage from adverse regulatory findings, and it was on a group of 24 UK PLCs across a sort of 10-year period. And actually the impact of the fines themselves was only 0.05% of market cap. However, the reputational impact was 5.5%. So actually what's harming the companies here isn't the reputational fines, it's that reputational damage. So I think companies do need to be thinking ahead.
Yeah, and I had a question for Steve on a similar note. I mean, one of the things that Anna and Robert have both mentioned is that making statements that, and it ties into the point Shelley just made, they're making statements that turn out to be untrue or unsupported is what leads you into trouble. Are you finding that you're getting contacted by corporates to do due diligence on the statements before they're released? So I know that in as part of the process of doing an IPO, what you'd ordinarily do is go through the prospectus line by line, and there'd be a due diligence document that sits behind it to support it. Are you being asked to do that type of thing in relation to public announcements on ESG related initiatives and the like?
I'm trying to think what the most politically appropriate answer is. In some ways, yes. Certainly, from a transactional context, any ESG statement is subject to much more diligence than it would have been in the past. But from just a general statement, no. In fact, we actually see the converse. We see CEO make a very grand statement that we will be net zero by 2030. And then you see the rest of the business have a massive panic and think, I have no idea how we're going to get there. And I think much of this stems from the way that, I'll use the word sustainability in this answer, the way sustainability has been held separate from the rest of the business. You look at the company's annual report and you have a sustainability report. It's lovely, the world's fantastic, we're doing everything that's great. And then the financial report is separate. When actually these two things are one and the same and are treated increasingly by investors as being the same. So you can't make a statement as a concrete company that you're changing the world for the better because everything's environmentally friendly, and then say, but we made a fortune selling the world's worst polluting houses. It just, the two things don't come together, and that's where we're seeing people trip up more and more often.
Steve and I think we're chatting about this earlier, saying we're getting more calls from lawyers who are looking to essentially bring claims on behalf of investors around misleading statements, as opposed to companies giving us a call to say, how are we doing? Should we be saying these things? So.
Yeah, it's a pretty open route given Section 1998 of FSMA. Look, guys, I think we're running short of time, so we might end it there. But I'd just like to thank Robert, Shelley, and Anna and Steve for all their time today. If there are further questions from anybody in the audience, please feel free to send them through, and whoever they're directed to will try and answer you independently. But thanks again. Appreciate everybody spending the time over lunch. Cheers. Bye.